So I happened to read about this really amazing line by Barack Obama the other day. It says, India is not emerging, India has emerged. And it just struck me that the power of entrepreneurship that India is exuding over the past 5 years, 7 years is impeccable. It will be, in the coming few years, it is going to be the face of India. And in this passion of creating something new, entrepreneurs often, whether intentionally or unintentionally is a debatable question, they often keep the legalities of entrepreneurship at the backseat. Because they are so much passionately involved with their product, with their concept, with their business, that legalities or technicalities of legal structure and these things take a backseat. So today we will be conducting a small session to sort of briefly educate you guys or make you guys aware about what are the legalities involved for startups or entrepreneurs.
And we'll be keeping this session interactive, so anyway. So we'll be keeping this session interactive. So at any point in time, if you guys have any queries, just raise your hand and feel free to ask any questions.
So let's try and understand the regulatory landscape of laws in India. So what happens is here, you need to understand that India is a simple country with complex laws. So it is humanly impossible to understand the legalities, the technicalities of so many. It is roughly said that India has around 33,000 laws existing right now at this moment. So it is humanly impossible to grasp all the points in all the regulations, all the rules. But it is imperative at this moment to understand that as an entrepreneur, you will be hit by some or the other law at any given point. At any given moment, there will be some laws which will be trying to regulate you, govern you, and before that thing takes a bad shape or a bad face, it is important for us guys to understand what exactly this legal framework is all about. Alright, so if you can see here, there are domain-specific regulators out here. Like for example, for financial systems, we have RBI. All of us we know what RBI is. Then there are antitrust or competition laws which are taking care of all the competition-related issues or legalities. Then there are certain other regulators like for taxation, there is Income Tax Department, companies, there is Registrar of Companies and the Ministry of Corporate Affairs. These things may sound a little bleak at this moment, but when you actually get into entrepreneurship, it will be important for you guys to understand what regulator regulates what. Which regulator is probably, it may create things bad for you, worse for you. I'm sure as an entrepreneur, at this point of time, you don't want to run into litigations unnecessarily and get your focus off your product or your core business. So it's important for you to understand what is the regulatory framework. So this is just a tip of the iceberg of the enactments that you will be hit at any given point in time. If not all, on an average, any entrepreneur will be hit by at least 5 of these acts. And as I said, roughly there are 23,000 laws in India, so the list is practically endless. So we need to understand that it is imperative for every entrepreneur to have an awareness what legalities he may have to face, what are the compliances that he need to comply with, what are the licenses, permissions, or such kind of things that you need to take before you start your product or before you get your product out in the market. So it's actually practically better to get these things sorted in the initial phase itself. In the due course of the discussion, we will be also discussing about such situations, such instances when entrepreneurs have faced massive problems because of ignoring one small legal compliance in the initial inception stage of the startup. So okay, this is one interesting point. We ranked 142nd as per the World Bank's Ease of Doing Business, and unfortunately or surprisingly or shockingly, our friendly neighbor ranks 132nd in this list. So that really surprises me.
Pakistan and Sri Lanka are actually above India when it comes to ease of doing business. So those countries are actually more, you can say investor friendly, business friendly. It's actually shocking to know. And last year, in fact, our rank was 138, and this year despite the change in government fees, slipped to 142. Hopefully, you can see a better score next year.
And the rank that we are talking about depends on many parameters. It's not a stringent set of parameters, but in general, like ease of incorporating companies, the taxation environment, the investor-friendly environment that you have in the country, and such other parameters. So this only goes out to show that it is a difficult or a complicated situation for an entrepreneur. But at the same time, we also know that just recently, Qualcomm was interested in investing in India. $150 billion they were interested in investing in India. So this only goes out to show that people are willing to invest in India, but because of such unawareness or such ignorance, people have been repelled of investing in India. So it is now you guys are the new breed of entrepreneurs. I believe it is imperative at this stage itself for you guys to be aware about what the legal scenario is. So first thing first, it is extremely important for you to choose the right kind of business structure or business model. There are roughly 4 to 5 business structures that you guys can use to market your product or to get your product in the market. So I'll be discussing 4 of them. Okay, so now we see here partnership firms and sole proprietorship. So I want to ask you guys, what do you understand when I say the word partnership firm or sole proprietorship? I really would like to get you guys interactive in this session. Vendors. Okay. Sorry. Okay, so that's closer to it. Yeah, so sole proprietorship is sort of one-man army, to be very crude. Whereas partnership is a team, it's like a tag team. Okay? So what needs to be understood at this point of time is, it is important to choose the right structure depending on parameters like what your product is, what will be the shelf life of your product, who are your target customers or target audiences, what is the kind of the product that you have, and what is the vision as an entrepreneur that you have. So for example, if you are willing to invite foreign funds into your product or into your company, then it makes no sense having a sole proprietorship, because again, when you are inviting foreign funds, you have to convert it to the private company. At the same time, if your product is short-lived, let's say it's a seasonal product, or comes once in 5 years or something, like for example, we have football World Cups. So if your product is based on something like a 2015 football World Cup, it won't be used in 2019 football World Cup, right? So it's a short-lived product. In such a situation, it makes no sense to have a private limited company or a partnership, because it is short-lived, and if you have a sole proprietorship, it will be easy for you to incorporate it and get out of it. So once you've achieved your targets, you can easily get out of it. So I have mentioned certain parameters out here, the earning law, number of persons. What brings, what I want you to pay some attention to is the third last point, second last point of credit worthiness. Now, it is important for us to understand the term or the concept of liability. So now assume I and Parth are in the partnership model, and in that situation, Parth goes out to a creditor, takes some money in the name of the partnership, and we realize that this partnership has no money to pay it back. Now what happens? If this is a partnership, the creditor can come. I hope you guys know what a creditor is. Yeah? So the creditor can come, ask Parth to sell off his car, ask me to sell off my bike, and he can recover his money from that amount. If it had been a sole proprietorship of Parth, the creditor would have done the same thing with Parth. Now let's go to two of the most important and prominent entities at the moment, that is LLP and company, private limited company. LLP, to be very crude, is just a glossed up and a better processed version of a partnership firm. We just spoke about liability. In partnership, in sole proprietorship, you have what we call as unlimited liability. So the creditor can come to my house, say that sell off your TV, give me my money, I'll go back. But if it had been an LLP or a private limited company, the creditor cannot do that, because the liability of a partner in an LLP or a liability of a member or a shareholder in the company is limited. So my assets, my personal assets are not at stake. much a safer version of an entity as an entity. Second important thing is, if we look at company, there is something called a share capital. So now under this share capital, what happens is, if I have a company, I can invite foreign funds. I can invite somebody like somebody who is sitting in some other nation who has piles of money with him and who is very enthusiastic about investing in India. I can just tell him, you invest in my company, I'll make you a shareholder of the company. With this kind of model, it is easier to invite funds. It is easier to invite more capital towards your company, and hence it ensures better growth and valuation of your company. So now we've understood four different entities. One being partnership and sole proprietorship, where the liability is unlimited. And second being LLP and company, where the liability is limited. Are we clear on this? Do we have any questions or queries on this? Anything? Do I need to explain it once again? Okay.
Just to add to what Mr. Ajinkya said, so it's important to know what kind of an entity that you want to incorporate for your business. So if you guys are all techies over here, so if you're into some technology consulting or something, so at that point in time, it doesn't make sense in incorporating a company. So you could go for maybe an LLP or a simple partnership. Whereas if you have some product that you develop after a lot of research and analysis, and you see the future, you see that product to be scalable. So at that point in time, you could incorporate a company, get all the intellectual property in favor of the company, and actually get investment from angel and VC investor and scale it up from there. So this is just one point that I would like to add, just to be clear, what kind of an entity works for which kind of a business.
So more or less what happens is, I'll just continue this point and I'll just make a statement that more or less the kind of entity that you choose for your business is almost entirely dependent on the vision of the entrepreneur. I think we've used that. Yeah, selecting the right business entity almost entirely depends on the vision of the entrepreneur. So the parameters that we discussed just a couple of seconds ago is what the entrepreneur seeks from that entity or sees in that product is the sole decision-making point of which entity you want to choose. So one entity may work for one entrepreneur, the same entity will not work for 10 other entrepreneurs. So it is for you guys to understand what your product is and thereafter make the decision of what kind of entity you want to incorporate. Okay, so Parth will take over on this.
So next slide please. So I'll be speaking. So this is how a typical angel and a venture capital investment process looks like. So the first stage is where the investor will identify the target. So the target is the founder company. An investor could be anyone from an angel investor to a venture capitalist to a private equity fund. The second stage is where there are preliminary negotiations and there are preliminary valuations that the investor will peg on your company. And at the same time, if things work out well, you will be signing a non-binding term sheet. We will be covering term sheets in detail in the subsequent slides. And the third step is where there is actual due diligence of your company. Now, what is due diligence? Due diligence is a process where the investor will actually deep dive into the minutest of the details of your company. So it could be, so if you just incorporated, he would do a background check on you as founder. He would like to check if you got your intellectual property in place or not. He would also like to check, whether there have been any financial irregularities in your business if it's already been running. So every possible thing that he can dig out, and you have to basically have to bear everything out before your investor. He can ask you for anything during this phase. Once he's satisfied with the due diligence, the findings of the due diligence will definitely impact the valuation that he puts. So it may happen that after a due diligence, the initial valuation that the investor puts on your company may actually go down because of some great findings. So supposing you got a patent that is pending, so you guys have invented something, but you're not sure whether you get the patent or not. And during the due diligence stage, the investor discovers that, okay, this could be a hit. So the valuation of your company could actually go down. So this is just one example. There could be many such instances. And so once the valuation has been checked, so there are negotiations, and then you guys sign something called as definitive investment agreement. So I know all these terms sound very intimidating, but just be with me for a while and things will be very clear for you. So So investment agreement is nothing but where they spell out what are the rights of the investor, what are the rights of you as a founder, how will the company govern, everything. So everything is laid down on paper, and finally after the agreement has been signed, there is that the investment that happens. Before the investment happening, there is something called as condition precedent, which we will be discussing in later slides. So, okay, I think you guys have, can you just do this slide again? So I think these, you wouldn't have got it right. So think of this entire process as an arranged marriage, okay? And now read it step by step. So I think now these things will actually make sense to you. Investor identifying target.
So the investor is who?
Who's the investor? So second step is preliminary valuation, signing of a non-binding term sheet. So when they actually start dating. So this is the second stage. And then you got financial due diligence, which obviously happens. Also, yeah. And then there is the third stage where so the negotiation and the signing of investment, you could consider it as an engagement stage, and the investment is the final marriage. So think of it that way, and you'll be able to.
What about the exit option?
What? So we'll be covering exit options later. Okay, so as I said, it's essential for any startup to be financially and legally sound, because any grey findings in the due diligence could actually impact the valuation of your business, and you don't want that to happen. So I know we're stressing this, but being lawyers, just be very clean on the legal front and the financial front, and everything else will be taken care of. Okay, so coming to term sheets. Now, what are term sheets exactly? You guys would have heard this term, term sheets often when we speak of angel investor and VC investor. A term sheet is actually a document which codifies the broad terms of the investment that's going to happen. So it's like the investor and the founder actually say yes, okay, we're interested in cracking the deal. Now let's take things forward. So that's where a term sheet comes into picture, and a term sheet is always non-binding. That means any of you guys are free to walk away from the transaction whenever you feel. So signing a term sheet does not necessarily mean that the investor will invest in your company or you have to offer shares to the investor. But there is one particular clause over there that when you sign a term sheet, you can't go and actually speak to other investors. So this is just one of the clauses. Otherwise, so you can just, maybe I'll just leave that slide on for a while. Okay. What are the broad contents of a term sheet? So basically, here we're talking about investment in a company. So first is the investment instrument. Now, the investment can either be through equity shares or preference shares. Equity shares are the shares that actually determine the valuation of your company. Convertible preference shares are those shares which actually get converted into equity shares at a later point in time. Debentures are nothing but loans. So basically, a company can raise money by only two means, by either issuing shares or by taking a debt. Now, those are some valuation metrics that you guys must be hearing on and on. It's called pre-money valuation and post-money valuation. Pre-money valuation is basically the valuation of your company before the investment is made, and post-money valuation is the valuation of the company after valuation is made. So assume you sell 20% of your company for 2 crore, so that takes the valuation of your company at 10 crore. It's simple math. Then promoters. So you as founders, okay, before I proceed, let me tell you some of these clauses over here, you might find them to be draconian, or you might see that they are not in favor of the founder, or they are heavily biased towards the investors. But let me tell you guys, here the investor is taking a very big risk on you, because when he's pumping in money, you are just an idea, and you're not even an organization. So there are some safeguards that he needs to build in to make sure that he gets his return on capital, he makes money. So some of these clauses might actually sound intimidating, and you may actually find out why these clauses are there, but they're essential from an investor protection point of view. So promoters, you as founders will be called promoters of the company, and the only thing that, the reason why you are defined is tomorrow when your company goes into listing, and there's an IPO, so the promoter is locked in for a period of 2 years, and the investor gets an exit. So the investor does not want to be called as a promoter. So that's the reason the founder, and anyway the promoter is the one who brings the business So you guys being the founders will be called the promoters. And it's important for the investor also to identify what are the key employees of your business. Now what is a startup? Basically it's just the people who are it's heavily reliant on the people. It's a very lean organization in the initial stages. So it's heavily dependent upon your chief technology officer or your chief operating officer, your CEO. So these guys are generally they are termed as key employees, and there are robust agreements which are signed with these guys so that anything happens to these guys, the company is not affected. So that's the reason why you got the definition of key employees. Use of proceeds as per approvals. Investor will always want his money to be used only for the purpose for which he has invested money. So that's one thing. Now conversion. So as I said, sometimes money does get invested by way of a convertible instrument. So how would the conversion happen? Decided in the conversion clause. Anti-dilution. Now this becomes a big technical area, but I'll just try to explain it in the best way possible. Anti-dilution. So today, let's take the same previous example. Today you're raising 2 crore for 20%, so that takes the value at 10 crore. Now tomorrow if you want to go and you raise 1 crore for 20%, so that means you're actually cutting the value of the company in half. So at that point in time, the company will be valued at 5 crore. So the 20% stake of the investor, which was earlier valued at 2 crore, is now valued at 1 crore. So for that 1 crore loss of value, the investor will want some compensation, and that's where this anti-dilution comes into play. It says that the company will issue such number of additional shares to the investor to make it compensate for the loss in value due to the falling valuation of the company. Post-investment shareholding is how the ownership structure of the company would look after the investment is made. And ESOP pool power. Now ESOPs are very interesting. You all heard stories about how Narayan Murthy's driver actually became a crorepati just because of ESOPs which were given to him by Narayan Murthy. So tomorrow when you're starting an organization, your employees would want to be incentivized by similar kind of remuneration. So they would look forward to you giving them ESOPs. So this is when it comes into play. You need to set aside a certain number of shares of the company for your present and future employees. Condition precedent and condition subsequent. So these are some criteria that you need to fulfill before the investment is made, like getting your patent, getting your regulatory clearances. Liquidity event and liquidation preference. Now, what are liquidity events? I know these are quite technical terms, but liquidity event is where your company is actually getting merged with another company, or where the assets, substantial assets, suppose you guys have actually developed some product and now you guys are selling off the intellectual property on that product, and that's basically your entire company is dependent on that intellectual property. So that could be a liquidity event, that could be defined in your initial term sheet. Rights of first offer, rights of first refusal, and preemptive rights. This basically says that you as an investor, whenever you guys are selling off your shares, you can't sell them like that. You have to first offer it to the existing shareholders of the company, and you have to first offer it to the investors. They will tell you a price. If you can fetch a price that is higher than that price, then you can sell it to a third person. Otherwise, you are required to sell it to the current investor. Next slide, please. Are we clear on this, or you guys have any questions? So yeah, we're not talking about exit or strategy, Ajinkya. So exit could be by way of an IPO or a strategic sale. So it's something like a taxi for sure selling to Ola. So that's something like a strategic sale over here. Tag along and drag along ride. So tag along rides is when if at all you intend to sell your shares to a third person, the investor has the option of coming along with you. So if you're selling, it's not like you sell your share and the investor remains with his chunk. So he has the right to come along with you and you can't jump. A drag along is the opposite, where the investor is going. And supposing your company has actually performed badly. Now this may sound quite a nasty clause over here, but this is just as an investor safeguard. We've rarely seen drags being exercised. So what happens in a drag is if your company is going nowhere. So your investor will say, okay, fine, now I'll do the tough job of going and finding someone who's worthy enough of running this company. But he owns the entire company, he just doesn't own my stake. So at that point in time, he can actually force you to sell your entire stake. So that's drag. Board composition, manner of voting, and legal rights. company will actually decide what will be the structure of the board of directors. In a company, all the majority decisions are actually taken by the board of directors and shareholders. So that's when you decide that what would be the optimum size of the board. So if there are 4 founders, so each of them would like to be on the board. And investor would also want a seat on the board to have some control over the business decisions that the startup takes. So ideally, board size would be 5 to 6 people with 1 or 2 people from the investor community, and 4 could be the founders. Exclusivity and confidentiality. So when you sign a term sheet, you can't go and speak to other investors, and there is generally an upper limit. So it's generally fixed at 60 days. So after signing the term sheet, till 60 days, you're not allowed to speak to anyone about the transaction or go and try and fetch some other investor. So that's exclusivity and confidentiality. Company to be exclusive vehicle for all intellectual property. So again, when the investors actually invest money in your company, they don't want you to go and develop something by the side and do something on your own, which is technically competing with the company. So there is generally a clause which says that all the intellectual property or the research and development that you guys do would actually be the property of the company and not it would belong to any particular individual. Rights and warranties. This is a very standard clause where you say that whatever you stated in the agreement, whatever you agreed to is true and correct. And if in future it's discovered that whatever you said was wrong, so what would happen is that it could be held out against you and you could be sued for breach of contract. So that's reps and warranty. Yeah, governing law and dispute resolution. So we live in India, so the governing law would be the Indian law. And dispute resolution is something that Ajinkya would speak to you in detail later. Over to you, Ajinkya.
So now Parth has just made a beautiful statement regarding startups is nothing but it's people. So let's come down to one important relationship of employee and employer. So we will be discussing briefly about employment agreement and the policy. Now, assume a situation when your startup has scaled up and you have a couple of employees, let's say 20 employees. So now what happens is, see, a startup is nothing but the unique point of startup is the idea that you conceive, is the thought that is put behind the product. Now, when you share that thought with your employees, it is very possible, it is highly probable that those employees, the ones with dishonest intentions, may just steal or take away your idea and start up on their own. Now, this is a very common phenomenon. This is a very, very common practice that is followed in the entrepreneurial circle. So, from the beginning, from the inception, as an entrepreneur, as a wise, aware, and a smart entrepreneur, it is imperative for you guys to make your position secure by getting your employees sign certain employment agreements. Now, here we try to understand what employment agreements are. So, very briefly, employment agreement is nothing but terms and conditions which the employee and the employer agree upon, have decided, have settled, and they want to continue their relationship as an employee and employer based on those terms and conditions. It ascertains the rights, liabilities, and duties of the employer and employee, and is a binding contract on both parties. Now, this is something important. Now, what is a binding contract is?